Hello and welcome to this edition of WFTV Law Talk, your guide to understanding the law and how it impacts our community.
From housing to healthcare and everything in between, we connect everyday issues to the law.
I'm Q McCrae alongside Jeff Harvey, the CEO of Community Legal Services, and together we'll help advance the mission to make legal access for all a reality. You're watching Law Talk.
Turning complex legal jargon into everyday talk. That's WFTV's Law Talk, sponsored by Community Legal Services.
All right, let's get right into it. We have a very special guest with us here today, someone who Jeff knows very, very well, John Martino, Director of Litigation over at CLS. Thank you for joining us today.
I'm so happy to be here.
Gotcha. Are you guys best buds or just work friends?
Jeff's my boss, but he's also my Obi-Wan.
Yeah, right. You guys go way back. So tell us about your beginnings.
Sure. So I grew up in Volusia County, Florida. I grew up in Ormond Beach. And from as long as I could remember, I've always wanted to serve the public. So after law school, I went to the state attorney's office and served the 7th Circuit of Florida as a prosecutor. And eventually I decided I wanted to put my focus really in the civil justice area. And I was lucky enough to find Community Legal Services.
And CLS as a whole, you help many people in different backgrounds, different issues.
Yeah, we help anybody who really needs it. There's so many people out there that need our help. We help people who are veterans, who are seniors, who are survivors of both domestic violence and disasters. There's so many people in the Central Florida community who need the help of attorneys to guide them through their civil legal needs.
I know as an outsider looking in, when I hear legal, I think pricey. I think, how am I going to get the money to make this happen? But you guys not only help with that side of things, but you also help with the education.
Yeah, absolutely. It's not just about representation. We do represent a lot of people every year. We make as many contacts as we can with the community. That can be a full representation, being in court with someone, but sometimes it's just giving them advice. And we also can't connect with everybody, right? There's a lot of people that need our help. About 3/4 of people every year have some civil legal need. But 92% of those civil legal needs either go unanswered or the people do not get enough help to address that legal need. So we are there to kind of fill in those gaps, or we call it the justice gap. We want to close the justice gap. And we do that not just through representation, but also through getting information out there.
You mentioned the justice gap, and part of your response to that is Litigation Corner. Tell us a little bit about why that makes sense. Why do you think Litigation Corner is going to help with that issue?
So the justice gap exists, and it represents the number of legal issues that are being unaddressed, right? And they are being unaddressed for a number of reasons, right? People don't know that legal aid organizations exist. There's potentially not the funding to support everybody getting help.
Not even enough lawyers, right?
Correct. And we have a good amount of attorneys that work for Community Legal Services, but we cannot represent every single person who knocks on our door or calls the helpline. So what we're trying to do is, even for the people who cannot benefit from our services, we need to get the information out there so they understand what's going on, so they understand how to assert their rights when they're dealing with their own civil legal issues.
Yeah, a whole group of people that they can't qualify for our assistance, but they also can't afford an attorney.
Right.
And so, we've got this Litigation Corner now. Tell us a little bit about what it's going to cover and how that might kind of help that group.
So the focus of Litigation Corner is to decode kind of the legal language that us as lawyers know so well, and make sure that anybody understands what they need to do when they go into the courtroom, or understands what the law is with regard to a particular statute, right? What is landlord-tenant law, right? What are your rights as a tenant when it comes to dealing with your housing situation? Those are the kind of things that we're going to help decode for people going forward.
And you've got 2 episodes out?
There are 2 episodes out right now about self-representation, how to handle yourself in the courtroom.
I always thought you had to have a lawyer with you. I didn't realize you could just go in and represent yourself, literally yourself, without any legal representation.
Well, and what's interesting about that, right? Like that's the distinction between civil and criminal, right? In criminal court, right? Generally speaking, if you can't afford an attorney, you have a public defender, right? And you have someone there representing your interest. But that doesn't exist in the civil courtroom, right? And so legal aid oftentimes is the only way to fill that gap, right? And so we do it either through representing people when we can, or getting the information out there so they can represent themselves.
Through the education.
Yep.
Thanks to Litigation Corner. That was really interesting, John. Thank you for your time. Thank you for everything you do for the community and with this guy.
Thank you for having me.
Yeah, We're pretty proud of John.
Yeah. I learned a lot from John today.
Yeah, we're pretty proud of him.
Yeah, I mean, first off, the Litigation Corner, can't wait to watch that, especially when he's going to be talking about how to represent yourself in court. I think that's really interesting.
Yeah, Legal Aid has been looking at self-help videos for years, but I think this is the first one that I've seen where actually explaining to people how to do it.
Right. Now, great stuff all around. All right, well, if you at home, you or someone you know is in need of legal assistance, you can always reach out to Community Legal Services at legalaccessforall.org. To learn more about today's topic and watch other Law Talk episodes, visit wftv.com/legal or watch Litigation Corner every single weekend right here on TV's 27.
Till next time, thanks for watching WFTV's Law Talk.
WFTV's Law Talk is sponsored by Community Legal Services.
Hello, and welcome to the first episode of Litigation Corner, a series where we discuss important issues affecting our community and shine light on successes achieved in the justice system. My name is John Martino, and I am the Director of Litigation for Community Legal Services, a legal aid program that covers 12 counties coast to coast in the middle of Florida. Welcome to Litigation Corner. Community Legal Services, CLS for short, is a nonprofit law firm. One of our goals of CLS is to eliminate something we call the justice gap. The justice gap is the difference between the legal needs of low-income people and the resources available to help them. Legal aid firms across the country, like CLS, work to minimize and someday hope to close the justice gap. For us, that would mean a society where everyone is equipped to recognize when they have a legal issue and that they can navigate the systems needed to help resolve it. How do we get there? Our mission is enhancing the lives of those we serve through accessible legal support, assistance, and education. Today, we're going to focus on education for those who do not have an attorney. For several years, I worked as a family law attorney at Community Legal Services. Over time, I came to realize that as much as we would like to help everybody who calls, there are only so many hours in a day, and we only have so many attorneys. That means that many people will face legal challenges without the ability to hire a lawyer. But here's the good news. You can represent yourself in court, and you do have rights. I've worked with countless individuals who have had to navigate the legal system without in-court representation. And while it can seem overwhelming at first, it is absolutely possible to do it successfully if you understand the process and know what to expect. So, if you have a hearing coming up, listen up, because I'm going to break things down in a way that makes you feel more confident about representing yourself. We'll talk about your rights, what you can expect in the courtroom, and most importantly, how to tell your story effectively, even if you don't have a lawyer by your side. Let's start with a term that you might have heard, pro se. When you don't have a lawyer, you're representing yourself, and the legal term for this is pro se. It's a Latin phrase that means for oneself. Now, just because you're going it alone, it doesn't mean you're powerless. You have the right to be there, to speak, and to present your case. You deserve to be heard, and the court is there to listen. Many people successfully represent themselves, especially when they're prepared and know what to expect. One thing you might hear about when you're preparing to go to court is an evidentiary hearing. What does that mean? Simply put, an evidentiary hearing is when the court hears and evaluates the evidence you're presenting. This could be in a family law case when you're showing proof of something like child custody or support. It's your opportunity to show the judge why your side of the story is the one that should be believed. At an evidentiary hearing, the judge will listen to both sides and decide what facts are most important to your case. You'll be able to present your evidence, call witnesses, and explain your position. But it's important to remember that not every hearing is an evidentiary hearing. Many hearings that you will attend over the course of the case could be status conferences. Status conferences have names like a status hearing, case management conference, and pretrial conference. These types of hearings are usually short. The judge will not want to hear you present your case at a status conference and may become frustrated if you try to present evidence at one of these hearings. Evidentiary hearings, such as a hearing on a motion that's been filed, a final hearing, or a trial, are the opportunities to present and defend your case. Now that we've touched on hearings, let's talk about evidence. Evidence is anything that helps you prove your side of the case. Evidence can come in many forms: documents, photos, witness testimony, even physical items. It's important to remember that evidence must be relevant to the case at hand and must be presented in a way that's acceptable to the court. Testimonial evidence. This is when a witness, including you, takes the stand and tells the court what they know about the case. Documentary evidence. This includes things like written documents, contracts, text messages, or emails that are relevant to the case. Physical evidence. Any objects or items that are part of the case. For example, a piece of clothing, a broken object, or something else that might help resolve a conflict in the case. Each type of evidence can help paint a clearer picture of the situation, but it's essential that you understand what types of evidence are most helpful to your case, and be prepared to explain why they matter. This takes thinking, and asking yourself, what does this piece of evidence help prove? So what types of evidence should you focus on most? That really depends on your case, but here are some of the most common and effective. Photographs. Pictures can be a powerful way to show physical evidence, like injuries, property damage, or things related to a custody case. For example, photographs of a home environment. Make sure the photos are clear and relevant to the case. In order for photographs to be admissible, you may need to testify that the photographs fairly and accurately depict whatever it is you're trying to show the judge. For instance, this picture fairly and accurately depicts the injuries I sustained. Text messages or emails. These can serve as written proof of what was said or agreed upon. They're incredibly useful in cases involving communication between parties. If you want to show the judge pictures, emails, or text messages, be sure to print them out and organize them chronologically to make it easier for the court to follow. You cannot just show the judge what is on your phone. If you do not print out evidence, it is possible that you will have to admit your phone into evidence along with anything else that may be on your phone. That will also mean that you will likely not get your phone back. You do not want to be in court having to make a decision of whether to admit your phone into evidence or not show the judge important pieces of evidence such as photographs. So be sure to get relevant evidence printed. And that concludes our discussion on handling evidence for people representing themselves. Remember, even without an attorney, you have a right to be heard. You have a right to present your case, and most importantly, you have a right to advocate for yourself. It may feel overwhelming at first, but with preparation and confidence, you can do this. Be organized, be clear, stay calm. The court is there to listen to your side, and by following the steps we've talked about today, you're setting yourself up for success. You've got this. Now we're going to move on to a story about how community legal services recently helped somebody. I want to tell you a story about Susan. Susan has been a homeowner since 2018. She owned a manufactured home in Volusia County. As is the case with many owners of manufactured homes, she owns her physical home, but she does not own the real property that the home rests upon. Late last year, she allowed her daughter and her daughter's boyfriend to move into her home. Unfortunately, Susan discovered that her daughter and the boyfriend were engaging in activities she knew could threaten her ability to remain in her property, and she really had no place else to go. In an attempt to preserve her housing, she moved to evict her daughter and the boyfriend. But when the two of them were arrested, the neighborhood where Susan lives issued something called a notice to vacate, ordering that she leave the property. This notice ordered Susan to get out in 7 days, even though she had taken steps to remove her daughter and the boyfriend. She now faced the dilemma. Does she move out, try to find a buyer within a week to recover whatever funds she could, or does she risk an eviction being filed with the court, forever staining her record when seeking future housing? Susan was connected to the helpline at Community Legal Services and later our housing unit. One of our attorneys spoke with Susan and advised her of her rights and discussed how she may be able to avoid eviction. Unfortunately, an eviction did get filed, but then CLS housing attorney Gage and paralegal Angela got to work, requesting reports from law enforcement and reaching out to the attorney for the housing provider. Eventually, they were able to advise Susan how to advocate for herself and obtain a forbearance agreement with the housing provider that would allow Susan to stay in her home. According to Susan, if it wasn't for Angela and Gage, I would have lost my home. She said CLS is a wonderful program, and she has since referred others to CLS. Here's another quote from Susan. This program really goes above and beyond to help people out that can't afford the traditional route with attorneys. Angela is professional and kind and generous, and I just can't say enough of good things about her. Gage, the attorney that helped me out, he is also just so kind and understanding to my problem and went above and beyond. I hope this program lasts for a long time because as far as I know, the community needs it and they need more people like this. So CLS would like to thank Susan for the kind words, and thanks Sabrina with the helpline, and Gage and Angela with the housing unit for their commitment to helping empower people in the community like Susan. That wraps up the first episode of Litigation Corner. If you have a topic that you'd like me to cover in future episodes, please write it in the comments. And remember that when you need help or a friend needs help, Community Legal Services is there for the community. See you next time at the Litigation Corner. Hello, and welcome to Litigation Corner, a series where we discuss important issues affecting our community and shine light on successes achieved in the justice system. My name is John Martino, and I'm the Director of Litigation for Community Legal Services, a legal aid program that covers 12 counties coast to coast in the middle of Florida. Last episode, we talked about evidence, when you can present evidence, what are the types of evidence, and how you can enter things into evidence. This week, we're going to focus on a litigation tool that is used to keep things out of evidence, objections. So sit back, relax, get your notebooks handy, and welcome to Litigation Corner. One of the leading reasons why having an attorney is often preferable is because attorneys understand the rules of evidence. One scenario where that understanding can be very important is when objections are made during a hearing. In court, you'll hear lawyers, or even the opposing party, object to certain things. An objection is when someone challenges something that is being said or presented in court. There are rules about what can be said, what evidence can be shown, and how things should be done. If you're representing yourself, you need to know about objections so you can protect your case. You don't need to be a lawyer to raise an objection, but to be an effective advocate for yourself, you should at least have some understanding of the most important evidentiary objections. Here are a few common objections that you might encounter or need to raise. Relevance. If something is being said or shown that doesn't relate to your case, you can object to it on the grounds that what is being discussed or shown is irrelevant. For example, if the other party is talking about something that does not have anything to do with the case, you can stand up and say, "Objection, relevance." By doing so, you are asking the judge to rule on the relevance of what is being discussed. The judge can then ask you for more information, ask the other side to explain, or if the judge believes they can rule on the objection without further discussion, they may do so. Next up, hearsay. Hearsay is when someone tries to introduce a statement made outside the courtroom. That statement can be from a person testifying or something stated in a document. The rule against hearsay is important to understand because it can be tricky. If someone begins saying, "My friend told me that," the remainder of that statement might be hearsay, and you can object. But there are a substantial amount of hearsay exceptions. For example, if you are in an injunction hearing, each party may testify to what the other party said outside the courtroom. That is because they are party opponents of each other, and that is an exception to the hearsay rule. Other common exceptions include statements made during an exciting or startling event, statements made to healthcare providers, and public records. Each one of these exceptions has its own rules, but just having a basic understanding of what hearsay is could help you in the courtroom tell your story and make sure that the other party is not inappropriately telling their side of the story. So, if the other party or another witness is about to say something that someone else said, you can stand up and object to hearsay. Next up, leading. A leading question is one that suggests the answer. For example, "You were at the scene, weren't you?" is a leading question because it pushes the witness toward a specific answer. You can object to leading questions, especially if the other party is asking them during their direct examination. However, here's a tip that you need to know. Not every leading question is inappropriate. During cross-examination, when the other party or their attorney questions you, or when you question the other party, you are allowed to lead the witness. In fact, it is advisable that when you are doing cross-examination, that you should lead the witness to direct them to the areas of discussion that you want to bring them to. Okay, so to wrap up the discussion from these 2 episodes on self-representation, let's talk about some tips that can help you feel more confident and prepared as you represent yourself in court. Be organized. Gather your evidence in advance and make sure it's clearly labeled and easy to access. You don't want to be scrambling during your hearing. Keep everything in a folder or a binder. Stay calm and respectful. Court can be intimidating, but it's important to stay calm, respectful, and patient, even with the other side or their attorney. The judge is there to make sure the law is followed, so being respectful to the court is crucial. Practice your story. Know your case inside and out. Be ready to explain the facts clearly, logically, and calmly. Practice what you are going to say. Also, if the facts of your case happened over a period of time, I would strongly suggest that you prepare a timeline with dates and important events so you have something to reference during the hearing. Know the rules. Familiarize yourself with the basic rules of the court. What time should you arrive? How should you address the judge? That is typically Your Honor, or you may say the word judge and their last name. Ask questions if you don't understand. If you don't understand something, ask. It's your right to know what's going on, and the court can often explain things in a way that will help you. Remember, Even without an attorney, you have a right to be heard. And as we've stated today, you have a right to object to keep out evidence that is not relevant to the case. You have the right to present your case, and most importantly, you have the right to advocate for yourself. It may feel overwhelming at first, but with preparation and confidence, you can do this. Be organized, be clear, and stay calm. The court is there to listen to your side, and by following the steps we've talked about in these first 2 episodes, you're setting yourself up for success. Now we're going to move on to the story about how Community Legal Services recently helped somebody. When Ms. Bennett first walked into our office, she was facing a difficult and stressful situation. Recently evicted from a short-term hotel due to her inability to pay, she was unsure of what her future held. Ms. Bennett had physical limitations, and without an income, she couldn't make ends meet. It was clear that she was struggling, but after listening to her story and asking thoughtful questions, we realized she was eligible for Social Security disability benefits, something she had never applied for before. Understanding that navigating the complexities of Social Security disability can be overwhelming, we immediately got to work on her behalf. We filed an initial application for SSD benefits, but unfortunately it was denied. However, we didn't stop there. Our team continued advocating for Ms. Bennett and filed for reconsideration. It was through this second effort that her benefits were approved, securing her a monthly income that would change her life. In addition to ongoing financial relief, Ms. Bennett received a back payment of more than $11,000, which helped her stabilize her situation. With monthly SSD benefits now in place, Ms. Bennett was able to find stable housing. Ms. Bennett's case demonstrates the power of our holistic approach to legal services. We don't just focus on the immediate legal issue. We take time to listen to our clients' stories, uncover hidden legal opportunities, and work tirelessly to provide long-term solutions. Our firm is proud to have a medical legal partnership with the Christian Service Center in Orlando, an organization dedicated to preventing homelessness. Through this partnership, we were able to combine our legal expertise with social services to offer our client a seamless support system. Ms. Bennett's case is a testament to the power of collaboration. Eric, an attorney with our MLP unit, and our friends at the Christian Service Center helped Ms. Bennett regain her stability to avoid further hardship. We're grateful for the opportunity to serve clients like Ms. Bennett and are proud to be part of the solution that prevents homelessness and supports those in need. Thank you to our incredible partners at the Christian Service Center and Eric from our MLP unit for your continued collaboration. Together, we make a difference. And that is a wrap on this episode of Litigation Corner. If you have a topic you'd like me to cover in a future episode, please write it in the comments. And remember that when you need help or a friend needs help, Community Legal Services is there for the community. See you next month at the Litigation Corner.
Thank you.